Good morning. I didn't want to leave dead air, but we are allowing people to enter into the Zoom room before we officially get started. We will plan to start the presentation, the discussion at 10:05. Just want to give folks a few more moments to join us. Okay, it is 10:05. So I just wanted to say good morning. My name is Donna Hershkowitz, and I am the Chief of the Programs Division here at the State Bar of California. I wanted to welcome all of you to our second Testing Accommodations Stakeholder Input Forum. I'm going to take just a couple of moments to provide some background on how we got here today, who's with us in this meeting, what we hope to achieve today, and the process that we're going to be following throughout today's forum. Let me turn first to who we have with us today. We are lucky enough to be joined at the start of this meeting by two members of our Committee of Bar Examiners, Dolores Heisinger and Vince Reyes. Several other Committee of Bar Examiners members will be joining us later today. They couldn't be here right at the very beginning, but will be joining us throughout. That is also true for all of you. We have 17 attendees currently. The expectation is that you will stay on the entire time if that is what you would prefer to do. But we also expect that plenty of people will be here long enough to get called on and give their comment, and then we'll be stepping out for the day. In addition to the members of the Committee of Bar Examiners that we have with us today, I'm also pleased that we have Sonia Dellin, a member of the State Bar's Board of Trustees, who is here listening today. We also have some representatives from our Testing Accommodations Unit. And the one that you'll be hearing from most today, I will be alternating the facilitator or moderator duties throughout the day today with Christina Dole. Christina is the head of the Testing Accommodations Unit here at the State Bar. So let's talk for a moment about how we got here. The State Bar is engaging in a review and evaluation, frankly, of all of our admissions rules. This is a healthy review that I think every organization should commit to do with some frequency. We are looking at our adopted rules as well as our operational practices to implement those rules, all of our candidate-facing materials, such as what's on our website, our FAQs, forms and instructions, what candidates see when they interact with the applicant portal of our admissions information management system, and even looking back at the logic that's built into that information management system. Testing accommodations is one of the first subjects that we have launched for this comprehensive review. As part of that process, on June 29, we held our first TA stakeholder input forum to hear your recommendations for how to improve the system. We had more than 35 individuals present information at the forum, largely about their personal experiences with requesting or getting testing accommodations from the State Bar to sit for the first year law students exam or the California Bar exam. We also had many other written comments that were submitted. Some of what we said and what we read in relation to that forum really resonated with me personally and with others at the State Bar with whom I discussed the issues. And that brings us to why we've asked you all to join us here today. Following that first round of stakeholder input, we crafted the framework that was attached to the agenda for today's meeting. This is a working proposal created by staff of the State Bar. I think I would describe the framework as the bones of the process staff is proposing. It sets forth the guiding principles and high-level explanation of the approach that we're proposing for the review of requests for testing accommodations. The framework will be the basis for the forms that applicants will need to complete and the instructions for those forms. It will guide how we process requests for accommodations. So those, the forms, the instructions, those will ultimately be the documents that people will be engaging with on a regular basis. In other words, you may never see the framework or use the framework document again, but it is the basis to develop all of those documents. It is the bones of the system. The framework is guided heavily by and borrows from the US Department of Justice guidelines for testing accommodations, as well as the consent decree that was entered in the matter of the Department of Fair Employment and Housing versus the Law Student Admissions Council in California. And it is designed to reflect a process that relies on the proof of past testing accommodations received on high stakes exams. It gives great weight to an applicant's qualified professional and limits documentation requests to those that are narrowly tailored. The framework describes a streamlined approach, which should reduce the time to decision from the process that's currently in use. In lieu of the several TA forms that are required today, this process envisions 2 forms only: the testing accommodations request form, and for those who need to provide additional documentation, the qualified professional certification form. I had hoped to have those forms ready for your review today also, but unfortunately, they were not yet ready. They need to be further simplified and go through a plain language edit before they're ready for critique. I'm envisioning, and my staff may be hearing this for the first time right now, I'm envisioning a small focus group that we would pull together to review the forms when they are closer to final form. So what can you do to assist us today? First, for those of you who submitted written comment, I want to say thank you for that. The written comment has been circulated to all the committee of bar examiners, to all of the staff here. I have reviewed it all. For those who will be providing comment at the forum today, as I mentioned, the goal is to get your input on the framework that has been proposed. The framework is intended to reflect a process that assures that individuals with disabilities have equal access to the exam as those without disabilities. It's intended to create a process so the exam is evaluating the test taker on the knowledge, skills, and abilities that the test is designed to measure, and is not a reflection of the effects of a person's disability. What I'm asking of you is to help us identify if there are flaws in the framework, additional things that we need to consider, or ways the framework may be either too loose or too restrictive. Speakers will have 5 minutes to present, so focusing your comments on the framework is essential. We may be interrupting presenters to help steer them to this focus of the framework if necessary. Just a couple of logistics for you. We have individuals participating via Zoom, and we have or may have individuals joining from the State Bar offices in San Francisco and Los Angeles. So we'll be calling for comment from each of those 3 separate locations. For those participating by Zoom who wish to make a comment, please raise your hand. In the interest, you'll see a raise hand icon on the bottom center of your screen. And for those participating by phone without video, you may dial *9 to virtually raise your hand. And in the interest of fairness and to ensure that we hear from as many participants as possible, we will be calling time at 5 minutes and moving on to the next participant. So as to assist in maintaining your privacy, for those participating via Zoom, we encourage you to only display your first name and not your full name in the Zoom application. You may want to go ahead and make that change. Wherever possible, we will use the first name only to call on you. But please know that when you are speaking, your full name may be displayed if you do not change it in the application. So with that, I am looking forward to hearing your insights. For those of you who are interested in providing comment, who will raise your hand. We will get started in just a moment. Let's go ahead and start with Benjamin. If we can unmute Benjamin's mic.
Yes, thank you. This is Benjamin Cohn. I want to first start out by saying that I think you've done the right approach by having a second forum to address the specific proposals you have in mind. I understand that the proposals for today are not rules revisions. I believe that the admission rules may be more procedurally lengthy to amend, and that there may be a subsequent proposal you have for us for those changes that affect more of the procedural considerations that would require rules revisions, and you're streamlining it by having the ones that don't require that first. And I agree with doing that so that it can be in place sooner. For the substantive proposals you have, it seems to focus more on evidentiary standards for the substantive decisions of approving the request. And for those, there are a few issues. The first is that the approval of accommodations that have been previously approved by a different testing entity are too restrictive compared to the DOJ rules. You have D and E on number A1. The prior approval was not for a limited period of time based on a temporary disability, and E, the applicant certifies that they are still experiencing the same functional limitations. That should be more than adequate to assure that the accommodations that were previously approved are still needed. So I'm concerned that you also have A, B, and C that then limit it arbitrarily to those who are are still affected by the same disability considerations, but may have started law school later than the other standardized tests, so that it's not in the last 5 years, or not or delayed retaking the bar exam after a certain amount of tries and now want to try with the reforms, and you're already abolishing the 5-year rule for the bar exam validity itself. Those same policy considerations should apply. There's no policy reason when you have D or E those are more narrowly tailored ways to achieve the same interest that a 5-year time limit on the benefit would have. The second issue with that is that you're excluding double time, which is not an extraordinary accommodation for most standardized tests or most disabilities, from this benefit. I think the DOJ best practices report put the threshold for not automatically advancing the same accommodation at more than double time, unless there was a visual disability and a different type of disability, rather than at time and a half. So I think that should match the DOJ's and not be further reduced to time and a half. The other thing is, if it was an uncommon accommodation that you're not typically seeing, you seem to be accepting it as well. Under these 1, 2, and I don't think that should be the case. I think that unless the standard test conditions moot it, that the fact that someone may have an uncommon disability or an uncommon recommendation shouldn't prevent them, if another testing entity found it appropriate, from getting that. Another key omission from the substantive part of the request is the treating expert deference required under the 28 CFR Appendix A at 795 to 796, cited extensively in the DOJ best practices report, that on issues of credibility, the treating expert will get deference over the reviewing expert. You're saying that the reviewing expert's decisions will be reviewed de novo by another reviewing expert on appeal, but you're not saying that you're going to give the treating expert more deference it's a standard of review by the State Bar staff fact finding on the holistic expert reports than the reviewing expert, which is required by the law. The other thing that I would suggest adding to this on the substantive is the best ensures a level playing field standard controls, and not a medical necessity standard that some of your experts have been applying in the past, and the incorrect definitions of fundamental alteration, undue burden, and reasonable accommodation that the experts have been applying, or sometimes the State Bar staff have been applying, that don't match with those in the case law. Now to the procedural.
Mr. Cohn,
Yeah.
your 5 minutes are up.
Okay, thank you.
Thank you. If you have additional comments, we encourage you to put those in writing. I look forward to looking at those. And if at the end of the meeting, there is, we have gone through all of those who are wishing to speak, we will certainly return if folks have additional comments that they'd like to make. Turning next, our next commenter is a phone number, last 4, 3584. Your mic has been unmuted. Okay, they are put down their hand. Moving next to Evan.
Hello, good morning. How are you all? Yeah, I just had one, I guess, a point of clarification here. So under Mega Section 1, A1B, the request is for the same or lesser accommodations approved for the MPRE or for the most recent first-year law students exam or bar exam. So at least I can only speak to my own experience. You know, I was someone who was told, ad nauseum that like, oh, the MPRE is a very easy test. And so I didn't seek accommodations for that specific test because I was told it was so easy. I didn't think I needed it, but I obviously sought accommodations for the bar. And my, I guess, concern or confusion is that 1B basically says that if you don't request accommodations for the MPRE, it will preclude you from seeking accommodations for the bar, because it says for the same or lesser. But if you have 0 accommodation for the MPRE, there's nothing less than 0, and the same as 0 is 0. So perhaps I'm reading too far into it, but it appears to me that this would preclude someone like me who got accommodations for the bar and didn't get it from the MPRE, excuse me, from getting bar accommodations in the future. I don't know if I'm misreading that, but that's just how I see that.
Thank you for that comment, Evan. Generally, we're not going to be sort of engaging in a give and take, but I do think it's important to provide some clarifications on the framework if there are sort of those fundamental questions like Evan just raised. And so the framework, what is laid out sort of in the beginning of the framework, if you've had prior testing accommodations, is intended as sort of the most streamlined, simplified process for getting testing accommodations on the bar exam or the first-year law student's exam. If those don't apply, if you didn't request accommodations, if you didn't receive accommodations, if you've never received accommodations in your life, if you have but not on those exams, then the intention is that the documentation process that is defined in Section 2, I believe it is, Section 2 of the framework is intended to kick in. This is one of those places where the fact that we don't have the forms or instructions laid out, but rather the bones of the process may have created some of that confusion, which is why I wanted to sort of take the opportunity to address Evan's question, because no, the intention of this framework is not that you would be precluded from requesting or be granted testing accommodations if you haven't had them on any of the designated exams previously. We would need to have your qualified professional certification of the need. And as I said in my opening comments, the intent is that those documentation requirements are much more simplified. There's more flexibility to what needs to be provided by the qualified professional than in the current process. So it is a sort of streamlined, simplified approach, but still need to identify what the disability is, how those functional limitations limit your access to the bar exam, and how the accommodations that are being recommended would in fact address that particular issue.
Thank you very much. I appreciate that.
Let's move on to William. William, you have 5 minutes and your microphone has been enabled.
Thank you very much. Can you hear me?
Yes, I can.
Good. The problem, I've been a victim of your accommodations process 3 times, and hopefully I won't have to go through it again, because I have tendinitis. And the first time, which is a programming issue, it doesn't tell you, it asks for a personal statement, which is sort of redundant in some cases, but it doesn't notify you that's not there and that hadn't been uploaded. But what I don't see is the interactive process under ADA accommodations, so that there is no possibility to say, in my case, it's unusual. I've had tendinitis since the 90s. I've been dealing with it. I know more about it than many doctors because I've been living it. Now, this procedure and the current procedure and this framework that's laid out doesn't address a interactive process. It's you give your you give the paperwork and the determination comes down from the mount. And in my case, twice, the accommodations or non-granting of accommodations came out after the deadline to appeal or the day of the deadline to appeal. And that certainly doesn't match the whole intent of the interactive discussion that's supposed to happen or that should happen. In my case, I had learned from the second exam with the half-hour breaks between each section, I was able to recover enough. But during the third exam, which I had passed, I was in pain for the next 2 months because, as doctors said back from the 90s, were keyboard maximum of 4 hours a day. That wasn't granted. I was granted being able to ice and a little bit of additional time, but I still had to push myself beyond the limits that doctors have been recommending for the last decade and that I've been living with for the last decade. And even though, yes, it's a little unusual to break the test into 2 days, that's not unheard of, because when you give additional time, it pushes some of the exam to the following day. And this is on the essay portion where it's all typing and you don't have the same restrictions as the multi-state. And just having it, the way this framework seems, it doesn't engage in the interactive process that it should engage in. Because a lot of people who have disabilities have been living with them. They know what their limitations are, or they at least have a fairly good understanding of their limitations. And this seems to be ignored when it's only related to what the doctor says. And also the issue, one of the issues is you wanted doctors from within the last 5 years. Mine is a chronic condition. It's been defined as chronic in litigation over 20 years ago. And why is there a need for me to see a doctor today to tell me and to say that you have a chronic condition? And that's all that I have to comment on this.
Thank you so much for those comments. William will be taking all of that into consideration. Let me go next to Paula. Paula, as soon as your microphone is enabled, you will have 5 minutes.
Good morning, everyone.
Good morning.
Good morning. I'm Paula Reed. I'm so glad you're having this conference. This is something that's been weighing heavily on me. I did apply for accommodations and was denied, but I was denied like 10 days before the exam. So that was problematic. So I just want to make sure that we follow the ADA's recommendations, because I followed them to a T on my request. I have not taken a bar in 25 years. I took 2, passed them right away. And I've since moved back to California, where I went to law school. And I want to now take the bar here. I'm 58. It's been a long time, but that's okay. But I have suffered tremendous abuse in my divorce and have post-traumatic stress. I know this is personal. It's a little hard to talk about, but I think I just need to throw it out there. I began studying and recognized that there was something going on. I was told by my psychiatrist to get tested. So I was tested by a gentleman who actually does testing and works with the bar a lot. And I have ADHD, I have dyslexia, but my post-traumatic stress which has had me inpatient, is the one that was really affecting me. And it was very disheartening because I wrote a very lengthy letter about how I recognized how this was affecting me. I had 2 very lengthy letters from psychiatrists who've been treating me, who know what's happening, know the family, and know how this affected me. Then I had one from the psychiatrist who tested me and one from my weekly therapist. And the response that I received has kept me from taking the bar and applying for another year, because I was told basically that my problem was that I missed my husband. And I don't know. I don't know. I was just flat out denied. And the way that I was denied was so demeaning that I want to draw attention to that fact to you. I don't know if I even want to appeal that decision, because I don't even know if I want it read. You know, it was so awful. But the main thing that I'm concerned with is that in the ADA, where it talks about qualified professionals, it says the testing entities should defer to their documentation. And I had just plenty of documentation. And none of the professionals that I work with could understand why this was occurring. In fact, one of them then followed up with a letter to you, but at that point it was just too late. So I went into the exam having 10 days earlier been told that I just wanted to go back and be married. And it was very upsetting. So I've waited, and now I'm applying again. It's a year and a half later, and I'm going to take the exam, but I still have the same conditions going on because I still have to have interactions with this gentleman. It's getting better, but I just want to make sure that I highlight how important it is that someone who is reviewing this, I understand that they are professionals and this is what they do, but it's very important to me that they respect the opinion of the professionals that have written letters. And it's also really important to me that there is some communication to those that are the reviewers, that when they do deny someone or discuss the situation, or maybe give them less time or whatever it is, that there isn't a subjective personal evaluation of that individual's situation, you know, to tell me that I just wanted to be married to someone who'd been abused, you know, by that individual. It is just an unnecessary comment. And so I'd like to make sure that, you know, as attorneys, you know, that we are following just the facts. You know, what are the facts? What are the rules? What is the process? What does the ADA say? Let's just streamline it and just make it very simple for those of us who are in need. So that's all I have to say. And I'm grateful that you all are here and you're taking comments, because it really feels very important to me. So thank you.
Thank you very much, Paula. I appreciate your willingness to share that painful experience with us. That those are the kinds of comments, as I said in my introductory remarks, some from the first forum really resonated. And I really appreciate hearing about that difficult experience. One of the things, because you are the second person who's mentioned it, I do want to point out that the framework provides that the State Bar shall give great weight to documentation provided by a qualified professional who has made an individualized assessment of the candidate. And you'll see sort of throughout the framework that there should not be a focus on the diagnosis. What is the condition? There needs to be a focus on what functional limitations a person has as identified by the qualified professional. And I hope that the framework as applied in your situation would provide you a much better experience.
I want to say thank you very much for including that in your framework. I did see that, and I did see that it mirrors the ADA. I suppose the reason that I'm jumping on here now is that the ADA's rules for test taking, including the comments by Congress, they were in existence at the
Yes.
time. So that's my only fear, is that, we already had that in existence, and now you're putting it into documentation through your office, your exam, I don't know, whatever that word is. And so that is really important, I think, for me. I just want to make sure that it's followed, I guess.
Yes,
Okay.
understood. And that is why we wanted to be explicit about these ideas and concepts in the framework. We are, as I mentioned, creating internal processes behind the scenes on how we would implement this framework, including training, sort of how staff is going to be organized, what level of staff is going to approve what. And so I would hope that, to the extent that you observed or felt like there was inconsistency in applying that requirement, that you wouldn't see that in the future.
Right. Thank you very much. And I really appreciate you having this meeting and speaking to us.
Thank you so much, Paula.
Okay.
Let me just check before I go to the next person on Zoom and see. I don't see anybody in Los Angeles. Is there anybody, unless I'm missing that, is there anybody in Los Angeles or in San Francisco in those offices who are there to make a comment?
Los Angeles here, we have no members of the public present at this time.
There's no members in San Francisco as well.
Perfect. Let's then move on. Next person online is Adnan. Adnan, when your mic is unmuted, you'll have 5 minutes.
Hi, I hope you're all well. I wanted to actually thank you guys for the work you've been doing. And I would just bring to people's attention that the division that actually handles accommodations, is there work being done to improve the operations of that division? And I say that as somebody who actually was successful in getting the accommodations I needed, but the procedure and also sort of like how it was done, one, it actually ends up causing the staff probably more trouble, and takes a lot more of their time. And I'm not sure they actually, at least definitely not in the first or the second instance that I took for the FYLSE or for the actual bar, they actually understood what I was asking for. And it was just interesting because, for instance, in the first year law student exam, I needed 10 minutes after every hour to rest. And at that time, I actually was able to walk, so it was an easier administration of the exam for myself. And my decision letter actually started by saying that I was being given the accommodation for dictation software, but not the additional time. But then if I read the letter, it actually tells me that I got an additional 30 minutes at the end of the exam, which is exactly the same thing, but it makes you want to call and see that, hey, did something go wrong? And that just creates work for the staff. So I'd really appreciate like a little bit of, just checking the operational efficiency of the staff. And I had a similar issue with the actual bar itself. And I had to actually ended up calling twice. One was I requested to take the exam in Orange County, but for some reason they wanted me to go to San Francisco. But like literally I called, and within 10 minutes of the call, they were able to change the place. But just calling and taking somebody's time when it could have been handled with an email. Similarly, the accommodations for the actual bar, I was given what I was asked for, but I was notified of it like, I think about a week after the deadline to appeal accommodations. And that just creates stress for no reason. And given that by the time of the second, not the second, but by the time that I took the bar exam, unlike the first year exam, I was wheelchair bound. So at that time, if I didn't get the accommodations I needed, I couldn't take the exam. And I was going to literally find out after the deadline to appeal had passed. So, I mean, again, it takes somebody's time to answer my call, and they were kind enough to call back, and it worked out. But it just, I mean, there is room for operational efficiencies, and I'm curious what you're doing regarding that.
Thank you, Adnan. Yes, as I had mentioned, we are sort of throughout the entirety of our Office of Admissions, looking at all of our processes and procedures, looking for efficiencies. What we believe is that this framework will streamline the processes, will allow those who had prior testing accommodations on high stakes exams within the past 5 years, their applications to be processed fairly quickly, leaving sufficient time for those applications that require more in-depth review to be reviewed and completed in a much more streamlined fashion, to be done more quickly than we've been able to in the past. Obviously, we need to roll out the process, see how it works, make changes as we go along where necessary. But that is what is envisioned, is that this will allow for applicants who request testing accommodations to get the decisions sooner, so they know how to prepare for the exam that they're about to sit for, or that they have time to appeal if necessary. Our next public commenter is Curtis. If we can unmute Curtis's mic. Curtis, I think you've been unmuted.
Yeah, can you hear me?
I can, thank you.
Okay, thank you. I want to make sure everybody that's able to take notes on this, please take notes on this, because this is something I had to battle with for quite some time. So I understand with the accommodations process, you want to ensure that, nobody is, faking any type of accommodations just to, try to get extra time to pass the exams. I get that. But my biggest issue with this is I believe the paperwork and whatever is required needs to change. In my opinion, I believe that a primary care physician or whoever's your provider, they should be able to fill out that paperwork. And it shouldn't cost more than whatever your co-payment is for regular care or your co-payment for specialty care. I had to fork out $1,800 to get my accommodation paperwork filled out because nobody within Kaiser was able to fill out the paperwork that the state of California was requiring. And I tried numerous times, and for Kaiser, they kind of have like a conveyor belt type service. But even with that, there was people that said, we can't fill this out. We're not used to this. And so I get it. You want to make sure that whoever has whatever disability, whether it's mental or physical, I know you want to ensure that people are being honest, but you can't make the burden so high to where, now it comes down to whether or not I can afford it. Because again, I had to pay $1,800. Now, thank God, there's fire in my belly, and maybe I might be one of those, silly law students that wants to take on all the world's problems, but I actually got my money back from Kaiser after they told me I would not get it back. And even the doctor that had to do the specialty assessment, he was surprised as well, because Kaiser just wasn't able to do it and I had to go out of pocket. I don't think that's right. Now, if I didn't have that $1,800 to pay to get that accommodation, I would not have been able to receive the accommodation. And I don't believe that any amount of money should matter when I'm trying to tell an entity or an organization that I need help because I have these issues going on. My money should not matter. And then also too, I just want to add in that, in my opinion, I believe that, the baby bar or the first year law student exam, it's used in a very sinister way, because as you guys know, to go through the if you go through the apprenticeship program or an unaccredited law school, you have to take the baby bar. Now, in my opinion, I believe the baby bar is deliberately meant to keep out the undesirables, because we know law school is traditionally very, very expensive. So if you don't have to pay as much money going to an unaccredited law school, or if you can pay almost no money during the apprenticeship, in theory, that would open the floodgates for a lot of people to go to law school that otherwise normally wouldn't be able to because it costs so much. So in my opinion, what I think the state bar did, they didn't want the floodgates opening up with, in their opinion, the undesirables. So they created this insurmountable test, or this giant of a test, which is the baby bar. Now, thank God for people like me, again, who has a fire in their belly. I passed the baby bar in the first attempt. I accepted the challenge. I accepted it wholeheartedly because I know what it's about. And in my opinion, especially in the state of California, it shouldn't be that difficult to be able to go to law school. It shouldn't be that hard. And if we have to take the test, then why not the other schools that are accredited? But I know I'm kind of veering off, going down a rabbit hole, but let me get back to the accommodations. Whatever paperwork that you guys come up with to verify that we do have a disability, it should be something that is it's high enough to be able to ensure that, okay, this is a bona fide situation, but it shouldn't be too difficult to where a person's primary care physician or specialist within their network cannot do it. And again, if I didn't have the $1,800 to prove that I had a disability, I would have been screwed. And I don't think that's right. And I think it's totally messed up. And maybe this is a hill that I'm willing to die on, but I look at not you guys individually, because I know you're not, you didn't create this beast, but all of these different systemic hurdles that are in place, I really believe it is designed to hurt people like myself. Now again, I thank God I had the money to pay it, but if I didn't have the money, I would have been screwed. Where else do you have to go where you have to pay all of this money out of your pocket to prove to somebody else that you have a disability? And again, I understand you want to prevent gerrymandering, you want to prevent, any type of, misconduct to give somebody an unfair upper hand. I get
I'm
that.
sorry, Curtis, your 5 minutes is up, but thank you so much for those comments. We will certainly take all of that to heart.
All right.
Our next commenter is Tom. Tom, once we unmute your mic, you'll have 5 minutes.
Okay, can you hear me?
We can. Thank you very much, Tom.
All right. Thank you for today. So I'm going to bring your attention to the fact that that we have to deal with primary care physicians that are specializing in our testing accommodation, which in my case is macular degeneration, a problem with the eyes, my vision. And I experienced it while I was taking the California bar exam. I literally had been unable to complete the exam, and I can say truthfully, it was because I could not read appropriately with speed, and I was constantly having to reread sentences because I did not realize at the time my vision had deteriorated so badly, and therefore I did go to an eye doctor. And then I was diagnosed with macular degeneration, and there were significant blood drops at the back of my eyeball, which identified that. And the eye doctor showed me and explained it to me, and he said it's a permanent condition. So that brings me to my main issue. What is this about a permanent condition? It does not change. What is this about? So we're gonna put bureaucracy in front of something that does not change. To me, that's just getting to the point of if you look at it and logically, it's ridiculous. But to me, at my age, there's deeper things. I know there's things behind all of this. This is bureaucracy. We can blame it on the bureaucracy. We can blame it, but somebody's got to take account for it. To me, this is discrimination. And I say that not lightly. I say that because, and I'm not saying whether it's racial discrimination, but it is discrimination against social economic, like the former guy that right preceded my talk, he was mentioning something, and I've got to jump on that for just a second. I believe it's a certain within the Cal Bar system. There's so many lawyers that go to these really expensive schools, and I applaud them for it, but they don't have the experiences that maybe social economic lower people with poorer people, let me put it that way, that don't have the funds to have those advantages. And what that's part of my story, because I was not able to afford an eye doctor. And it was only because I was a veteran, I have an expeditionary medal for putting my life on the line for this country, that the VA paid for this, and that I was able to arrest my progression of macular degeneration, which is a permanent condition. It can only be slowed down. I can get worse, but it can never get better. That's the definition of permanent condition. So, you know, now we're talking about also a third party, like somebody mentioned earlier, my doctor has to refill out. After a 5-year period, I have to reapply from the original standpoint and have doctor verification. And this is a third party that is delaying me. And therefore, that's why I use the word discrimination. This is not, this was not accidentally put in front of me. The bureaucrats know that this would require third-party doctors to refill out my application. And when I gave this to my doctor, my eye doctor, I gave him the forms to fill out because I printed it out for him, thinking I could save some time for him. And he looked at me. It was just, it was unexplainable. He was incredible. He did not believe that this was being required of me. And this was back in March 14th. I have it documented, and he still hasn't filled out the application as far as I know. So this is this is causing me further delay, and this is on top of being able to pass this exam, which I have to study for. This is complicating things. This is something that is causing more obstacles. This is an obstacle. I know my time's about to be up, but this is something that it's really, it should be just made a motion. It should be passed. This needs to be just acknowledged and not put me through the ringer. Thank you. I'm done.
Thank you, Tom. And I did want to take the opportunity to provide another clarification again to an issue that, because it's come up a couple of times. One of the reasons why I wanted to have the forms ready for you today, and I'm sorry that I don't, is that there is a description that we have proposed in one of the forms that I was just scouring through the framework as Tom was speaking, and I saw that it wasn't in there, and so you wouldn't have picked up on it. But we were looking, I believe it's the DOJ guidelines, which talk about documentation from a qualified professional, looking at sort of the past 5 years, if the accommodation is based on psychological, cognitive, or learning disabilities, or anytime after you reach the age of 13, if you're seeking testing accommodations based on any other disability. As I said, I believe that's from that age 13 for those disabilities is set forth in the DOJ guidelines. And that is part of what this proposal would include. And so I did want to say that because it was not apparent from the face of the framework. Okay, we don't have anybody else on Zoom who has their hand raised at this very moment. If LA or San Francisco can let me know if you have anybody physically in the office who would like to make a comment.
LA here, we have no members of the public in office.
San Francisco here, we don't have any members of the public either.
Okay, we do have a new hand on Zoom. Diego, when we unmute your mic, you will have 5 minutes. Diego?
Hello, can you hear me?
I can. Thank you very much, Diego.
All right, so I'm a completely blind student that I just took the first year law exam, and I'm completely blind because my eyes were removed. So I'm one of the few fortunate people who have an accommodation that is so incredibly obvious it cannot be denied. And for me, this shows how the process could be done. It took me the submission of one form, two forms, yeah, two, and it took about maybe a few days to, I was able to submit my form. I got my answer very quickly as to whether I'd be allowed to have my accommodations or not. And then I also was able to modify my accommodations at the end because I required a USB headset, and I was able to send an emergency request, have that request granted, and thank you for that and all the work that all the people put into this. But it shows that when you do have a very obvious accommodation, the process that was there before was successful at providing the things that you needed. It's just, it needs to be improved for absolutely everyone else, and I mean everyone who doesn't have an extremely obvious accommodation like myself. And I was just wondering about timelines, because I'm going to be taking the first year law exam for this October, and that one's already been approved. But I was just wondering about timelines for the process and the actual changing of the requiring of the new forms. But that's really it for me. I've had fortunately or unfortunately, however you want to look at it, a rather smooth run of this process.
Thank you, Diego. And I'm glad to hear that your personal experience was a positive one in seeking these accommodations. The timeline for completion of these depends on how this forum goes in part. We will be taking this feedback, summarizing the feedback. We will be presenting rule change proposals to the Committee of Bar Examiners in October. Most of the rules that we currently have don't need to be updated to reflect the new framework. And so we believe we can implement much of the framework without rule changes. And so we are hoping to implement this as soon as possible.
All right, thank you for letting me know. And I really would have, as all of us will admit, been very glad to actually read through the forms, but that's all my comments.
Thank you very much. We do not have any hands raised at the moment. So is this a sort of good opportunity to maybe give our transcriptionists and our ASL interpreters a 15-minute break?
That would make sense, Donna. Do you want to break for 15 minutes and wait perhaps for more people to join or more comments to come to us?
Absolutely. We are prepared to be here all day. We understand that people may have said, well, this forum goes till 3. I'm going to come on at 2 and provide my comments. Staff and the interpreters and the transcriptionists will be here for that entire time to take comments. So let's go on ahead and take a break at this point for 15 minutes. And when we come back, if there's anybody who is prepared to make a comment at that time, then we would happily take it. Devin or Tyler, if you can just put up a screen that says that will be returning in 15 minutes. Thank you, everyone.
Thank you, everyone. We are just coming back. It is 11:15. I want to give everyone a chance, for those that may be on the phone or joining the webinar, if you would like to make a comment on the framework for the testing accommodations process. We would love to see hands raised and comments. I am going to check in with our Los Angeles office and our San Francisco offices to ask if anyone in either office has joined us to make a public comment.
LA here, no members of the public have joined us.
San Francisco here, no members of the public have joined us.
Thank you. I do not see any hands raised on the webinar or the phone-in portion. What I am going to recommend, as Donna has previously communicated, we are going to hold this webinar open through 3 p.m. today. But I think what we are going to do is put up a sign to let people know that we are actively taking comments and that we are here. But we're going to put up a sign to let people know that they might see us off camera if there's no one that is wanting to make a comment directly at this time. I will continue to monitor the webinar for anyone that may join us that may want to make a comment. But you might hear a little bit of dead air in between as we wait for the next person to come on. I still see no hands raised, so can we go ahead and put up a slideshow just to let folks that may be joining us know that we are here and wanting to take comments, but we may go off screen. And I will come back and check on the group periodically. I will be off camera, but I will be watching and monitoring and hopefully looking for anybody else that would like to make a comment.
Christina, I see we have a hand raised.
Thank you, Donna. The extension ending in 3036 should be unmuted, and you should be able to speak at this point. Oh. And it looks like we just lost that person. Let's give it a couple minutes to see if the person wants to call back. Okay, I see that we have our caller back. Our caller should be unmuted now and should have the ability to speak. Okay.
Hello?
Yes, we can hear you. Thank you.
Thank you. First of all, thank you very much for opening this up to the public. I am a law graduate and I went through the process of requesting an accommodation for a mental disability. And I just want to piggyback what some of the people from the public have said regarding sort of the scrutiny of the response that you get from the bar. Sometimes there are some comments in there that are subjective and it can actually cause some emotional, damage, receiving, the authorities' opinion in such a way that's pretty harsh, especially when we're disclosing things that are very intimate, personal, painful. Secondly, I just want the bar to really, really, really think about us in a way to where it's user friendly, right? Perhaps there's somebody that we can talk to or a hotline where we can ask questions, because some of us might be dealing with cognitive overload or trying to navigate through the various forms, and we have a simple question. I just hope that the State Bar is really thinking about us. For example, today, we could also state when there'll be a lunch break or when there'll, be some time to take a break, or, repeating the number to raise your hand, just things like that, where I think we need the bar to really think about us in that way. I know of people that have experienced temporary disabilities, and it's sort of an interdisciplinary problem to their health. And I'm looking at your forms, and there's, a form for testing accommodations for physical disabilities, and I'm speaking with respect to the bar exam. Testing accommodations, Form B, physical disabilities verification. And in the very beginning, it says that you're requesting this accommodation on the basis of a physical disability. And I do see that you do provide the option for us to select as many forms as we need. So I think what would be important is just like an extra page that says, you know, if you need one or more of these forms, you know, just do the best that you can, because of what I suspect is going to happen is that somebody dealing with a physical disability, such as the speakers, maybe with tendonitis, or if I may, and maybe somebody else with, or the same person with a mental disability, and maybe that person has a visual disability or a cognitive disability, and they actually need to submit 3 or 4 forms. Each form asks you for, you know, the professional's evaluation on the basis of that particular disability. And so maybe this person needs, I don't know, 50% time or double time or 25% extra time, I don't know. But because of one of these disabilities, it's a major impact on them, let alone 2 or 3. So I think where it sort of feels scary for the applicant is that you submit your forms, your packet, maybe you have 3 different professionals, 3 different packets, physical, mental, cognitive, and, you know, based on my experience and having the reply and, you know, partial denial of the accommodation, I feel like someone who's submitting multiple forms for an accommodation, it's like up to the bar to decide, like, okay, you get 15% for this disability, maybe 25% for that one, and maybe 10% for that one. I think it's just a little bit hard because I feel that with stating a certain disability, for example, physical disability, I'm going to just throw a hypothetical, somebody has carpal tunnel, you know, the bar will say, well, you know, we don't think they need the full amount, right? But then how does the bar sort of figure out like an in-between among several disabilities? When the form really the form sort of assumes that it's just one disability that you're asking for extra time for. And I hope that my question is, or my comment is clear. But as you can see, it is a little bit overwhelming. And I really just want to drive the point home that I hope the State Bar is intentionally thinking about us and other people that need to participate in this process. But it's extremely burdensome. It's extremely burdensome, and I think it would only take a few extra pages of clarification or a hotline or a dedicated case manager that's confidential within the Accoms department to sort of help navigate this. The bar is really thinking about us. Thank you so much for your time.
Thank you for your comment. A couple of things I just want to piggyback off there is thank you for looking at the testing accommodations request forms as they are on the State Bar website currently. As Donna mentioned earlier, we do have a plan to streamline those forms to make it less confusing, perhaps less onerous of having to fill out multiple forms, and maybe putting the form together in one form that applicants need to fill out, maybe 2 forms. Thank you for the reminders of using the feature of *9 to raise your hand. Absolutely, that should have been given to the people on this webinar. *9, you can raise your hand. *9, you can lower your hand. And thank you for making that comment as well. And another comment that you had just made regarding a dedicated case manager system or some kind of hotline that applicants can call in to talk to a staff member. And thank you for that comment. It is something that the State Bar also is talking about and putting together on our end as well. So more to come on that feature of a streamlined and less labor-intensive testing accommodations request process. And again, *9 for those of you that would like to raise your hand, make a comment. I can visually see the Los Angeles and San Francisco offices. I do not see any members of the public in either of those offices. And I do not right now see any hands raised on our webinar. So at this time, again, I am going to ask staff to put up a PowerPoint slide to let the stakeholders know that we are still manning and watching this forum for hands being raised. However, because we do not see anyone wanting to make a comment right now, we may go off screen, some of us, but we are here and actively monitoring if anyone would like to make a comment. Solicit any feedback that you have for our testing accommodations process and specifically the framework as posted on the State Bar website.
Tyler will be putting up the slide shortly. We're just adding a little note for members joining by the phone.
Thank you for adding the *9. Appreciate that. Okay, I see another hand raised. Thank you so much. The caller with extension 5500, you should have the ability to speak.
Hi,
Or-
thank you for doing this and thanks for patiently being sitting there. I see you on my Zoom, but I called in because I have you on listen only on my computer. My question is, when you have testing accommodations and something happens when you're tested, does the proctor have any ability to modify that situation? And I'm talking about specifically two things happened to me where I guess twice I had physical problems where I have tachycardia, where my heart started racing and I collapsed, and there wasn't anything I guess the proctor could do. One of them actually documented it. The other one, I don't know if she documented it, but they said there's no flexibility. They're like, you have to go to the doctor, that's it. So I didn't know if there's any anyways, I'm done with my question. I was just trying to figure out if there's any flexibility on accommodations from the testing person, if they see anything, if it was documented, if that would allow, I guess, to get a better understanding of the person's need for an accommodation.
So, as you've mentioned, proctors do report any incidents that may happen at a test center. However, the accommodations that are granted at for a testing applicant are pretty much solidified through the testing accommodations notice prior to showing up at the exam. So all accommodations that are requested should go through a regular process of being approved at the staff level within the office prior to showing up at an exam site. If something were to occur at an exam site, again, the proctor is asked to fill out an incident report to make sure staff is aware of it, but all accommodations should be complete prior to showing up at the exam site itself.
Well, thank you for that. I didn't know if there's any, I guess, flexibility or whatnot, because when I went for another time, I mentioned what had occurred, and they said they didn't have any documentation of it, so I didn't know. I recognize that some people have an ability to have lots of doctors, but some of us, I guess, don't have the financial means to some of these accommodations. Either the doctors don't want to write everything out or that type of thing. So that's why we're seeing if there's any way that gets put in a file so that at least can show that someone does actually have a physical issue that may not be apparent, but may happen in the testing situation.
And if I may suggest, this is probably a conversation that's best had one-on-one. Some of these
okay, I'm sorry. Yeah, I don't
are
mean to be
case by case. Yes,
I'm sorry about that. I was just since you were all sitting here for the last half an hour and I was just sitting back listening, I thought I'd at least bring up.
Oh yes, no worries at all. It's just there are certain things that are obviously very case by case, and so that's certainly a conversation that that we would be happy to have with you offline.
Okay, thank you again. I appreciate everything everybody does. So I know it's not easy to try to make it fair for everybody. So I appreciate everything that everybody does, and I think you guys are trying hard. Thank you.
Thank you for your comments. We do appreciate your feedback. We do appreciate you being here on the forum with us. And you can, again, *9 to raise and lower your hand. I do see Kathleen has her hand raised. So if we can unmute Kathleen, please. Kathleen, you should have the ability to speak.
Hello?
Yes, we can hear you.
Hello, thank you for having the session. My name is Kathleen, and I want to thank the bar examiners and the committee for having a session. I also want to thank the bar examiners and the committee for undertaking this very difficult challenge. I was granted first I was denied accommodations, and at the last minute, 2 weeks before the exam, out of nowhere, I was granted my accommodations. So I want to thank the bar examiners for that blessing. It was still very difficult because I did not have enough time to get adjusted to the accommodations. But I do thank you for providing them to me. In the event that I have to retake the bar exam, I would be able to have enough time to practice on using those accommodations. I'm actually looking at, in the documentation requirements, section 2A2. One of the places where I was denied was in the documentation section. It says the applicant has a physical or mental impairment. I have both, physical and a mental impairment. It makes it seem as though you have to choose one or the other, and that there are some people who actually have both. And so unless you're requiring us to choose one or the other, it would be nice to be able to know whether or not we can put all of our problems, all of our disabilities down. Not problems, but disabilities. Because there's a difference. Disabilities are things that are not going to change. Problems are things that can be changed. So that's one. And that's under the section 2 documentation requirements is 2A2. And then the other thing, I want to piggyback on one of the things that one of the commenters mentioned about sticking to the facts and to be respectful in the analysis for the persons who are being chosen to evaluate the factual determination from the doctors that the bar applicants select to complete their forms. I was highly embarrassed by mine. The information that was sent back to me about my condition, the reason for my denial, was very embarrassing and very unprofessional. And one of the denials is said that because they called one of my doctors an unknown doctor. So that was one of the reasons why they denied my accommodations, because they didn't know who she was, even though she worked for Kaiser. Or just totally denying it because they felt like I had so many problems that they couldn't determine which one they were, so I didn't have any problems at all. Or no disability at all, even though I was on disability, federal disability. That wasn't enough. So if it would be nice for them to stick to the facts and be respectful in the analysis and to do so in a professional manner. I would just want to piggyback on that. And then the last thing is under section number 7, under documentation requirements, where it states that the state bar shall not reject or deny an applicant's request for testing accommodations based solely on the applicant's average or above average IQ or history of academic success. I want to commend you on that, for adding that in there, because my application was denied based on that. And that was written in the report given to me. So I want to commend the bar examiners for changing that and actually implementing that change. And that's all that I have. And I just want to thank you for your time.
Thank you, Kathleen, for being a part of the forum today. Okay, can I get a verbal confirmation from Los Angeles and San Francisco if we have anybody in either office for public comment?
LA here, we have no members of the public present currently.
San Francisco here, no members either.
So then, Christina, let's go ahead and have Tyler put up the notice. We will go off screen until we see a hand raised, at which time we will happily return.
Thank you all. We are coming back online because there is a public comment. If we can unmute the person calling in from extension 3036. And you should have the ability to speak now from the extension 3036.
Hi, are you able to hear me?
Yes, we are. Thank you very much.
Okay, thank you. I understand that it was sort of made clear that the forms for testing accommodations could be changing in the future, of course. But I just wanted to sort of provide just some feedback on where maybe some of those changes could occur. And it's not that I'm going to go through each question, but I think there's a little bit of an ambiguity between a permanent disability and a temporary disability. For example, on Form B regarding physical disabilities, question 7 says, is this a permanent condition or impairment? And I think there should be a box that says unknown, because it just says yes or no. And it says, if no, when is it likely to abate? You know, this could be a temporary disability, or it could actually become a permanent one. And I think having a box that says unknown and maybe a space for explanation on why it's unknown would be important. Because I based on the experience of getting a partial approval or partial rejection, however you want to call it, the person that replies to this really does scrutinize sort of every single statement and even what was not stated. So hypothetically here, if this is a temporary physical impairment and somebody checks off this is not a permanent impairment, and when is it likely to abate? You know, this doctor might say, well, you know, we thought it was going to get better, but we're not sure. And just on saying we're not sure, I just know that the bar is going to say, well, you know, then we're not sure either. We don't know how severe it is. What I do want to echo, though, is that I do appreciate that the bar will, when granting an accommodation, I don't know if this is case by case, but they do say, you know, this accommodation is for this upcoming bar and then the one after that. And I think that's where maybe that allows another like reevaluation of the individual. And I want to just really emphasize that that's highly appreciated, that there is some wiggle room, and that I guess if that individual needs more time based on their disability, then they would actually maybe ask for that. But I do appreciate in some cases, a year grace period to have that accommodation applied to the next cycle. So yeah, I just wanted to just call attention to, you know, some of these questions are absolutes, and in some cases, you know, for some disabilities, it may not be known. And the individual could be working with a provider or providers to monitor their own health. So again, it's just like, just really thinking about people with disabilities, whether permanent or temporary. Again, thank you so much for holding this session and listening and considering our comments. And I look forward to seeing new forms before the next bar exam, hopefully. Is there any feedback on if that's going to be possible, or would we be looking out for, you know, a new form in 12 months? I'm just curious. Thank you.
Thank you for your comments. I think it's too early at this stage to really say when those new forms will be out, but please know that the State Bar is working on this actively right now, and it is our goal to get those forms out for review as soon as possible. Okay, I am not seeing anybody in the San Francisco or LA conference room. I am not seeing anyone with a hand raised. So at this time, we will put the slide up. I will continue to monitor for hands raised if you would like to make public comment regarding the TA framework. Thank you all. Hello, everyone. It is currently 2:05, and we have a few people here ready to make comments. Okay, I see two people looking to make comments. I'm going to start with who I believe is someone that has not yet made a comment. So could you please unmute Peter? And Peter, you should be unmuted at this point.
Hi, can you hear me?
Yes, we can. Thank you.
Well, my name is Peter Maduro. I am a inactive attorney and now in a second career as a clinical psychologist. And I work with a number of disabled folks, some of whom have pursued careers in the law and grappled with the process of preparing for and taking the bar exam and run into the question of appropriate accommodation. So I have comments. Unfortunately, I'm joining you just in time to tell you that I no longer now have time to articulate my comments verbally. And so would ask if you could just verify how I might submit them in writing and whether I have time to do so either later today or early next week for your consideration.
Absolutely. Thank you. Yes, we will still accept written comments if you would like.
Okay.
Written comments at this point. Thank you, Devin, for receiving the written comments to date. We'll continue to use your email address for future. The email address is Devin, DEVAN, dot, last name McFarland, McFarland, at CalBar, CALBAR, .ca.gov.
Christina, if I can just clarify, if the interpreter got that was Devin with a V, like Victor.
Thank you. And if that was a mouthful, we also can take emails to admissions@calbar.ca.gov.
Okay. Fabulous. Well, I'm sorry for the head fake, but my schedule is getting over, and I think I'll be more articulate on paper in any event. So I'll be back in touch, but I did want to just announce my presence and my interest and concern. So I'll share my thoughts in writing soon.
Thank you very much.
Thank you. Have a good.
I am able to see in San Francisco that we have no public comments. LA, can I just confirm we have no public comments or people waiting to make a public comment in the Los Angeles?
LA here, we have no members of the public here currently.
Thank you very much. I am going to turn it back over to Benjamin. Benjamin, you should have the ability to unmute yourself at this point.
Thank you. And yes, I wanted to follow up on my comment from earlier this morning to discuss where I think the rule revision required changes should focus. And I just wanted to highlight that the most problematic parts of the procedural considerations is how long it takes to provide one responsive iteration of responsive feedback on the State Bar's positions on any given set of argument, evidence, documents, or new requests, clarifications. That gives it very little number of times to clear up misconceptions and let any disagreements, if there are any, be on the substance rather than the premises. And if the state bar could take less time to get some sort of responsive iteration back, maybe not even a final decision, but something that would allow premises to be cleared up in a more collaborative way, and that's prompt enough that it would allow multiple iterations per exam cycle, not necessarily the appeal. I can understand why you want to limit CBE review to once per exam cycle, but the staff review, then that would definitely help quite a bit if there was a time limit, instead of the applicant getting like 10 days and then the state bar taking 60 plus days, if there was some shortened amount of days before some additional communication happened. The second biggest issue is that it's all written submissions. There's no hearing. I think for something that with this much interest liberty interest in a chosen career affected and potentially limited after years of time and hundreds of thousands of dollars of law school education costs, there should be a hearing at least once per exam cycle for the applicant, and if available, their experts and legal counsel to engage directly with the state bar and maybe clear up misconceptions that way, because there's an opportunity for live back and forth rather than time to work around the schedules of a lot of different treating and reviewing experts to get information submitted not live. So I think a hearing should be added to the process. I know the admission rules expressly forbid it, oral argument at least, to the CBE. That should be changed. So those are my highlights for the procedural issues. And I wanted to also make you aware that the reason you may have fewer commenters at a time right now is because the link on the agenda is broken. And if you don't call in or enter the meeting code manually into Zoom, it won't let you in. It will say webinar expired if you just click the link to open in Zoom from the agenda or from the browser. And that may be why so few people have chosen to join. Also, it does coincide with the California Lawyers Association annual meeting. So I'm actually joining in the short windows in between sessions, but that may also be a reason why you might want to find a couple alternate dates to collect comments on, because I think a lot of people who wanted to speak couldn't today. Dr. Maduro, who I heard before me, also seems to have a conflict that was specific to today. So just wanted to put that out there as well. That's it. Thank you.
Thank you, Benjamin. Do want to confirm we have gotten written feedback or written comments from you as well. Appreciate that. We will continue to receive written comments today as well. As for the webinar link, we do realize that you have to enter a webinar conference ID. It is given on the agenda for you to enter the webinar ID. Once you enter the webinar ID, it should give you access to this meeting. I apologize if people have been experiencing a warning message, but if you enter the webinar ID, you should have access to the meeting. I, at this point, don't see any other public comment from San Francisco, Los Angeles, or those joining us online or on the phone. So I will ask staff to put the PowerPoint slide on. And again, we're here monitoring. If anyone would like to make a comment, please press *9, raise your hand.
Tyler, if you, perfect, thank you. So thank you so much, everyone. We have reached the hour of 3 o'clock. This was always anticipated as an opportunity for individuals to drop in as it fit their schedule to provide a comment for us as we finalize the shape of the framework for our testing accommodations processes for the future. Never anticipated that there would be folks on the call the entire time. I do want to make a special thank you to Committee of Bar Examiners members Alex Lawrence, Vince Reyes, and Robbie Brody, who have stayed on with us through the bitter end. We had a couple of committee members who made it most of the way and just recently lost them. So thank you all. For those members of the public who are still listening, and I see we've got a couple of you, thank you so much for your comments. They will be incredibly helpful to us as we continue to shape the process. As I mentioned at the outset of this meeting, the input that we received during the first input forum on June 29th was incredibly helpful in guiding our thoughts as we were making our initial plans on what this structure of the new framework might look like. It really, the information that we received was very helpful in having us think through the particular challenges that some of the applicants face. So thank you so much for being willing to share some very personal information and to help improve the process for others as we move forward. With that, we will close this testing accommodations stakeholder input forum. And I expect that further conversation about what transpired today will happen at the October 14 Committee of Bar Examiners meeting that we've got next month. So thank you to everybody.
Thank you.